So, dear friends, welcome to this series organized by the British High Commission. My name is Christoforos Christofi, and I have the pleasure today to host a discussion with the chair of the Bar of England and Wales, Ms. Amanda Pinto. Amanda, welcome to our panel.
Thank you very much.
So, we are discussing today with Amanda two very interesting areas. Number one, we will discuss about technology, legal technology, the impact of COVID-19 in the legal profession, and where the balance lies in justice for the future. And in the second part, Amanda will speak to us about the women at the bar, the women's position, how to improve things at the bar and justice in general. So before we start, I would like just to make a brief introduction to Amanda. Amanda is chair of the Bar Council for 2020, having been chair of the International Committee from 2014 to 2018. She was called to the bar in 1983 and practices at 33 Chancery Lane in London. She specializes in business wrongdoing, international fraud, corporate crime, bribery, and money laundering. She is described by peers as hugely experienced, immensely clever, collegiate, hardworking, and cerebral. Amanda was appointed a part-time judge in 2003, QC in 2006, and a bencher of Middle Temple in 2014. She writes Pinto and Evans on corporate criminal liability. The fourth edition is imminent, and the chapter on sanctions in the leading textbook Smith, Owen, and Bodnar on asset recovery 2019. She writes the corporate crime chapter for the leading textbook Blackstone's Criminal Practice. Amanda is also a trustee of the Flynn Foundation, working to improve justice systems and the rule of law globally. She is a champion of the first 100 years project celebrating women being admitted to the legal profession. She is deputy chair of the Tate Members Council, representing over 140,000 members for the Tate Galleries. She has been shortlisted for Chambers and Partners 2020 Outstanding Contribution on Diversity and Inclusion Award. So Amanda, quite impressive resume. Welcome again. So before you give us your first presentation, tell me, are you the first female president of the Bar Council or not?
I'm the fourth. I'm the fourth woman. Mm-hmm. I was going to deal with that in the other talk actually, but I was going to say I'm the fourth woman. I'm the second to have a family, and the first to have them living at home with me instead of going to boarding school.
Okay, okay, this is very interesting, and I understand that you are very busy these days. You are also a practicing lawyer, right?
Yes, this year I've taken a step back from practice, so I am still working, but not nearly as hard at my personal practice as I would normally be. Mm-hmm. And this year's been completely full on as chair of the bar. It's been incredibly busy liaising with the government, with the senior judiciary, with HMCTS who run the courts and the Ministry of Justice, and also with colleagues, mm-hmm. both in the UK but also around the world, to mm-hmm. try and get through COVID-19.
Okay, so I have many questions about you, especially the way you understand the role of the Bar Council, because I see that there are regular interventions and statements, even touching political matters in the UK, and this is very interesting, about the role of lawyers and their associations and so forth. We have our elections here, the Cyprus Bar Association elections in the next few days. So first of all, let's start about technology and COVID-19. We had the opportunity to discuss this matter last week in the first seminar series of discussion with Sir Jeffrey, and he had some very interesting things to say. So I give you the floor to give us your ideas, and then we can discuss this a little bit further.
Thank you very much. Well, I think when we talk about technology and courts or justice and ways of working, particularly post-COVID-19, I think that the overriding principle that we must have at the forefront of our mind is access to justice.
Mm-hmm.
Access to justice in conducting the business of courts and tribunals, from the starting proceedings to obtaining and enforcing judgments. Because if people cannot access the structures that will enable them to exercise their rights, then they don't have access to justice, and their rights are underused and maybe even worthless. And also, of course, delay is a huge problem in enabling people to access justice.
Mm-hmm.
And we have seen that technology and remote access to courts and tribunals is a way of limiting the ways that COVID-19 has been a barrier to access to justice. So what I would say is that we've got to make sure that we provide a sufficient substitute in terms of engaging with the process. It's got to be understandable. The formality of the court must be retained. The results must be true, and it must be value for money. If it's not, and we've seen this in practice, some hearings either aren't effective or are insensitive to participants, then what we find is that access to justice isn't working. And we must also remember that technology is difficult for some people. Sometimes we call them the digitally excluded, that their needs must be borne in mind so that the justice system works for everyone, whether it's a person who's in a courtroom physically or remotely using technology. Mm-hmm. Before the pandemic, the usual way in which court hearings were conducted in England and Wales was in person. But in order to deliver justice in lockdown, it quickly became vital to move to remote hearings, be they by email, phone, or a video platform. And it's worth remembering that during lockdown in April, so not long after the country in effect was locked down, over 90% of hearings that were achieved were done remotely. So it's proof that online courts can be a help. And from that experience, we all accept that the justice system has undergone changes that are and should be here to stay. Mm-hmm. In particular, the use of remote hearings to deal with short or uncontroversial, perhaps procedural business, is unobjectionable. And in fact, we would say it's welcome in many cases, even after the current crisis has passed. With the second wave of the virus already happening here, I don't know what the position is in Cyprus, it's imperative to use remote hearings in both the short and the long term, and we must make them as effective as possible so that access to justice doesn't suffer. One of the ways that we specifically must deal with that is to improve the quality of remote hearings, the quality and reliability of the technology used, and the support and bandwidth available to participants to conduct them. And what we've seen is that the Ministry of Justice, the judiciary, the professions, and those that support the courts have embraced technology intensely and with real commitment. But it's right to say that different areas of legal work have responded differently and with different levels of success. It's a very varied picture of what is being and what can be achieved in different jurisdictions. And one of the things that's been clear is the different levels of ability, enthusiasm, and available support for judges and other participants towards this way of working. So if I just take an example, it's the commercial court, which has a great deal more resource from the participants, has worked extremely well with remote hearings. It has been much less successful in the county courts, the lower civil courts in our country. So I'll come back to that, if I may, in a moment. And it's obviously also right, we've discovered that there are some hearings and procedures that are simply not suitable for remote hearings to get a just result. And again, I'll come back to that. If I just start with crime, though, at the end of March 2020, so even before COVID-19 court closures occurred, there were backlogs in cases. In the magistrates' court, so in the lower courts that do crime in our country, there was a backlog of 326,000 cases. That was up 11% from 2019. And in the Crown Court, the backlog was about 40,000, up 21% since 2019. And that, if I can just explain why, was because there was a break on sitting days. The government decided they did not want to put money into having the courts open, in effect. They wanted to save money. And that really came home to roost with COVID, because obviously that has been an immense break on the system. Coping with both, that's to say the backlog that existed and then the complete shutdown for a short time of many courts, but not all, that has been a significant driver in using technology. The Crown Prosecution Service, who do almost all of the prosecutions in our country, estimate now that as of the beginning of March, the trial backlog in the Crown Court rose 43% between the beginning of March and early May. And by the end of May, it was 53%. So that's a really shocking number of cases to have to deal with. The Crown Court receipts are rising at about 1,000 a month. And that's not all court trials. Some of them will be guilty pleas or perhaps appeals from the magistrates' courts. But it does give you a flavour of the problem that's needing to be addressed and why it's so important that part of the volume is addressed by perhaps double using courts. I'll come on to talk about that perhaps in a minute. But, one with the court being set up in the normal way, and then perhaps a judge sitting in a room that's got the technology that they can then go through cases dispensing justice in a proper way, but in effect double using the courts by using a remote court as well. The magistrates' court backlog by August was up to 500,000, but now I'm happy to say that we're at a point where less cases are coming into the system than are being disposed of in the magistrates' court. So that is a really good turning point. But it does rely on all parts of the system being at full stretch. And one of the main ways in which that's been accomplished is the use of what we're calling CVP, which is the Common Video Platform, which enables remote hearings to be had in the magistrates' court and other courts, Crown courts and civil courts now. But just dealing with the magistrates' court, they can have remote hearings into prisons, so the prisoner does not have to be brought to court or police stations. And that has got a lot of advantages, actually. So we restarted doing jury trials in June with a very few number taking place, perhaps 10 court centres across England and Wales. Now we have well over 200 courtrooms taking jury trials, in addition to those courtrooms that will be taking non-trial work in the Crown Court. So you can see that really huge strides have been made. But to begin with, and still to some extent, more than one courtroom was being used for every jury trial because of social distancing. And so it became more and more important that we were also able to use remote hearings for other work. So that really, in a sense, deals with the criminal courts. If I can turn to the civil courts, county courts, so the lower civil courts, were very slow off the mark, not just because their judges were often redeployed to do urgent family work, but because they did not accept digital bundles. We didn't have e-bundles, which we do now. I think in Cyprus you might still be on paper, but so which is a very big restriction on moving things remotely, actually, and using the best of technology. And I can thoroughly recommend e-bundles, actually. The systems were also incapable of processing cases, and in many areas of law, Although the courts were said to be open, justice was just not being achieved, and the backlogs in civil were also building up. Family were more successful in keeping going on various platforms. At the very beginning, we had the parties agreeing with the court which platform they'd use, whether it was Zoom or Teams or Skype for Business, or almost anything went, because there was such a desire, particularly in urgent family cases, such as where a child needed to be housed or was at risk, to ensure that justice was being delivered. And so there was a real commitment, actually, by the family bar, family solicitors and the courts to ensure that justice continued to stream through the family courts. Mm-hmm. But what we did find, and I think it's worth noting, is that there were some cases which simply were not suitable for remote hearings. And if I can just give you an example, it was very stark in the family court, where you had a litigant who was at home having a phone court hearing with their children around them in their home. And that court hearing was about where those children should be housed and who should have custody of them. There were cases where children were ordered to be removed from the house, in which they were literally physically, as it were, in the hearing. Of course, they were not on the phone, but the devastation to that litigant was enormous, and it didn't feel as though justice was being done. It wasn't formal. It was very difficult, obviously, for that litigant to understand and appreciate what was going on. And so all in all, it proved that it didn't work in some sorts of hearings. So I think it's also right to say that there are also some important potential access to justice and efficiency benefits in the right cases. And if you take an online divorce project, for example, in 2018, I think, Christmas of 2018, they started the online divorce project, moving from paper to online. 49% of decree nisi are now processed digitally, up from 6% in 2019. Far fewer mistakes are made in the online process. There are far fewer delays. And so technology has also made the process faster. For those granted a decree nisi in April to June of 2020, the mean average time from the date of the petition was 23 weeks, which was down 11 weeks quicker from the same period in 2019. So that's a positive. And if I can perhaps summarize disadvantages before you come on to ask me some questions that we found, because I think the real importance here is to work out what works well and what we need to be mindful of. So experience has shown that judicial interaction is different in remote hearings from those face-to-face. So sometimes the hearings are less effective at isolating the issues or allowing an argument to be developed. I mean, just as you and I are having a conversation and we might find ourselves talking over each other, it's a bit more awkward on a screen or on a telephone call than it is in person, to be able to read the body language and read the mood of the room. Secondly, everyone says hearings are more tiring. And I think that has to do with the focus. I think I'm looking at you all the time, you're looking at me. It's not that same thing that you have in a courtroom where you're actually looking around a bit and you're focusing on a particular person. Then you might put your gaze down to your papers, then you might turn to your opponent or whatever it is. It's just much more difficult. The management of witnesses, especially in cross-examination, is less satisfactory when conducted remotely, and that may have an impact on the quality of the evidence given. And actually, if the person whose technology is required doesn't have robust technology, that's going to almost certainly impact their evidence. And I mean that by them perhaps getting frustrated, quite apart from them fading in and out. concerns about the technology might be distracting and therefore affect the quality of the evidence. And they're difficult remote hearings to present effective advocacy involving evidence or complex narrative submissions. It's difficult to pin down, but it's often the intangible benefits of human interaction that happen in in-person hearings that shouldn't be ignored. Mm-hmm. Just to give you a personal example, yesterday I did go to court for a case of mine. Mm-hmm. One person was in the hearing remotely. One barrister was in the hearing remotely. Myself for the prosecution and a defense counsel for a defendant were in the courtroom. And it seemed to me, because we do have these hybrid systems and hearings at the moment, mm-hmm. There is an inequality of experience. It was very easy for me just to lean over, say to my opponent, okay, you don't want the 5th of November as the date. What about the 27th of November? Mm-hmm. So much easier than trying to deal with it on, I don't know, WhatsApp or some kind of side chat where you don't really want the judge to see. So I think those are just sort of basic, but really important at driving the case forward. Mm-hmm. And crucially, the experience of litigants. And I've mentioned this a couple of times, but I think it's so important. If you go back to what drives all this, which is access to justice, mm-hmm. We have to be sure that litigants are getting a proper experience of what is going on. They often feel detached when remote hearings are used compared to in-person hearings. So to summarize, we're endlessly recalibrating where the balance should lie.
Thank you. It was a very interesting presentation. Of course, you raised a lot of issues, and I will try to pick up on some that I consider important. So do you think that at the moment we are undergoing a revolution because of this COVID-19 and the restrictions that are imposed on access to justice and delivery to justice? And do you think that this thing will stay? I mean, even after things normalize, hopefully a vaccine is found and in a couple of years we go back to where we used to be before 2020? Or is this something that has come to stay, this hybrid form of hearings?
Definitely the latter. I don't think it's a revolution in England and Wales. I think it's an extension and a great acceleration of what was happening anyway.
Is it an acceleration though?
Yes. We had already got in criminal courts, we have the digital case system. So we're already digitalized. We would have some witnesses, for example, from overseas would give evidence by video link. The criminal procedure rules actually changed in order to put the, as it were, the emphasis on using those methods rather than not would be the norm, whereas mm-hmm. the other way, it used to be the other way around. And what this has done is to drastically improve the quality and support and the practice and experience of court users. That has been revolutionary, mm-hmm. but I don't think that the actual use of technology is something completely out of the blue for us. And actually what we did find is that those jurisdictions and tribunals and courts that were used to using technology a bit adapted far better generally than mm-hmm. those that did not. But it is also, I'm afraid, it has to do with resource. So if you are, as I said at the beginning, if you're in well-resourced proceedings, you are likely to do far better. And so, for example, our High Court, every judge has their own clerk, so they can sort out the technology. The judge concentrates on the hearing, mm-hmm. Whereas in the lower courts, or perhaps not so well-resourced jurisdictions of our courts and tribunals, it's just a much patchier experience. Mm-hmm. Mm-hmm. And actually, just to finish, actually, the Lord Chief Justice, our Lord Chief Justice, said in the Mansion House speech, which the City of London has for the judiciary, he said, I think this was probably late, yeah, it was late July, actually on my birthday. And that's how I spent my birthday.
Yeah.
He said, we will never go back. It will not be the same. And nor should it be, really. But, you know, we have found ways of delivering justice, sometimes better value, a lot easier. I mean, one thing which you probably have in Cyprus a little bit, but we have practitioners who go on a train for 2.5 hours, do a 20-minute hearing, come back on a train for another 2.5 hours. That's gone.
Well, certainly this situation offers flexibility because you can work remotely either from the office or from home without having to go to court. But what about the human right aspect and the access to justice? Don't you think that, at least so far, the understanding was that the right to be present before a judge physically was a human right that was synonymous, or it was, how do I say it, incorporated in the right to justice? When we said access to justice, what do we really mean? Do we mean to have the possibility to file a case remotely, or go before the judge and the jury and the lawyers develop their arguments orally before the court?
Well,
because
so
this is changing.
Yes. So, I mean, I think Article 6 doesn't say you have the right to appear physically. I don't think that's there. I think it's an interpretation. And
yeah, it's not per se, but what was the understanding? At least in Cyprus, when we said access to justice, what we really meant was to physically go to court.
But there is I don't disagree with you in the sense that that was everyone's expectation. But you have to ask yourself the question, if you are in lockdown for 3-4 months, do you just say, well, you don't have any access to justice? It's either you do it in person, well, you can't do that, so we're just not going to give you any access to justice. You'll just have the delay problem, and that is a problem for access to justice. That evidence gets worse, memories fade, people become disengaged. We've had lots of examples, actually, of victims of crime just saying, you know, I'm not going to wait 2 years. I have to get on with my life. And so if that's, and you can understand that, and so these things are all balancing acts, I think.
Yeah. So relevant to this is what percentage of the population is IT literate, so that it will be able to participate in this process. Do you have any statistics, for example, in the UK, as to how many people can use a computer or can use the internet?
I don't. But what I would say, Christopheros, is that many people have smartphones, and that's all you need. That's all you need to be physically in the hearing. I mean, that is the way that many people can access a hearing. And one of the other interesting things, actually, is that you might think people would say, well, video is best because then we can see people and so on. But we found, particularly in some civil cases, that it's better to have telephone hearings rather than video, partly because of bandwidth, partly because of all the reasons that you mentioned, whereas people are very familiar with speaking on the phone. But having said all of that, I think what the kind of pivotal point is where there is going to be live contested evidence or a terminating ruling of some description which will impact that person's rights, subject to appeal forever.
Yeah.
So I think those are the sorts of hearings where we think they should, generally speaking, be in person. But there must always be flexibility so that you can make the best of the available means of delivering justice, even if it's not as good as being in the old-fashioned way that we're both used to and love.
Yeah, but what I'm thinking is if we start this way, the way that you have described, of course, in Cyprus, we are ages away from what happens in the UK. We are at the stage where a pilot filing system, online filing system is being tested these days, and we don't have hearings remotely. We still have to go to court and do things the way they used to be done. But are we moving towards a direction where, Amanda, machines will take over at some time? Artificial intelligence. I mean, if we start by doing this remotely, then where will this end? Sir Jeffrey, for example, suggested that for small claims, we have a procedure like the eBay conflict resolution where there is artificial intelligence up to a point that decides the claims. And I know that you are against it, reading your inaugural speech. So
I'm not against it. I just think you need to put the balance in the right place. And actually, I mean, Sir Jeffrey is at one extreme of enthusiasm.
Okay.
He's very keen. I was going to say evangelical, but on a serious note, I mean, what you want is people who have rights being able to enforce them, and that's the most important thing. What we know about many small debt claims is that they are very straightforward. And we also know that many people don't pursue them through the courts because they think the courts are too expensive. So if there is a procedure that is very simple to use and is suitable for very simple claims, I think that's a good thing. I don't think it's a bad thing.
Okay.
As far as AI is concerned, and obviously you can make that parallel with eBay or Amazon or whatever it is.
PayPal.
But actually, typically it's a very different type of action to the ones that we're used to. And I believe that the statistics show that those are cases which would not come to lawyers otherwise. It's not that the machines are taking work away from lawyers or the courts. Actually what they're doing is they're enabling a whole other group of people to access justice. That's a good thing in my view. AI, I think, is useful up to a point if it's very carefully managed in terms, for example, of very large scale disclosure exercises and discovery. Very useful. You've got to make sure that it does not reinforce false prejudices by the way that it's operating, which is a real problem. It needs human interaction to make sure that it's suitable, but it will almost certainly make less mistakes than humans. So that's another good thing. I think I don't really buy into the slippery slope.
Yeah. Well, I agree with you that for civil claims, civil cases, this whole remote thing, hearing, would not pose any particular problems. Where I see problems is in the criminal justice system, in the cross-examination of witnesses in criminal cases where credibility is at stake. And I'm really wondering how can a jury or a judge decide on the credibility of someone that is giving testimony remotely or is being cross-examined remotely. I mean, the whole point of cross-examination is the face-to-face interaction, isn't it? So if that's gone, I don't know.
I think the answer is that as a general proposition, that is not where we're going. We are generally speaking, we have appreciated that you've got to have, in normal circumstances, you have face-to-face cross-examination and examination of contested witnesses. However, it's right to say that last year and the year before, I was involved in very big fraud cases where we had foreign witnesses and we cross-examined them by video link. That they gave their evidence entirely by video link. We had a huge screen in the courtroom opposite the jury, another one for the judge, and the barristers could also see. it wasn't as good probably, or potentially, as it wasn't as easy as doing it if they were physically there, but it saved that person coming from the continent to the UK, giving evidence for a couple of hours and then going back.
Yeah.
And honestly, I don't think it had such, and that was a witness that was seriously cross-examined.
So when you said before to have a sufficient substitute, this is what you meant? I mean,
yeah, it may not be as good, but when you are considering things like cost and convenience and the delivery of justice overall, I mean, there are no 100%, are there? Everything is a trade-off, and it certainly is the case that we've used video evidence before. And can I just give you an example, which has nothing to do with any of this? It's been going on for a long time, and that is the evidence of vulnerable adults and children by video link. So the first thing that typically would happen is that their video of their account to the police would be in a room with totally separate. It would be recorded. That would be their evidence in chief, and then they would typically be in another room in the court building, again specifically for the purpose, accompanied by somebody who was nothing to do with the case, so that they would be able to be cross-examined without being in the same room as the defendant, and all of the sort of overwhelmingness and fear of being in a huge courtroom. So we are used to that. We have used that. I don't know whether that's used in Cyprus.
Yeah, for child abuse cases, yes.
Yeah. So then you will have experience of the differences and the difficulties of it, but also it's a trade-off, isn't it? It means that witness gives evidence, and frankly, they may not have given evidence at all if not for those measures.
Okay, so another aspect that I want to bring up, and perhaps this is my last point, how do you think this revolution or not will change the legal profession? Will it change the way we try the cases, the way we prepare for the cases? Will it impact the income of lawyers, you think?
I think, interestingly, where it might have an impact is in relation to the difference between barristers and solicitors. If a solicitor can organise their day so that they can be in court hearings, like short court hearings, administrative hearings, without leaving their desk, then they may very well do more of those hearings than otherwise they would, because they wouldn't be in Limassol and Nicosia in the same morning. So that might have an impact on barristers, but that is, I think, something that will be worked around. I mean, one of the things that we've been thinking about is whether it's easier or more difficult for people, for example, with caring responsibilities, being able to do remote hearings. And for my part, I think it's very uncertain what the impact will be. I think ultimately, if I may say so, what you want, this might be a bit sacrilegious to an audience of lawyers, but what you want is the best value for the client. And if that means that that they're not paying for you for half a day to get there and back and do your short hearing, but they're paying for you for an hour, well, okay, you might earn a bit less on that case, but it's better for access to justice, and it's better generally.
I think, you are right. I think it works both ways, though, in the sense that if you can do the job quicker, then you can allocate more time to other tasks within a day as well. For example, we see this now because the cases in the Cypriot courts that are not for hearing are now processed via email and through other digital means. So we don't have to go to court as we did 6 months ago just for to get a date, to change the date of a case. So this has freed a lot of time for us, for lawyers, that we can invest on doing other things and become more productive. And I guess this may be reflected to the client as well at the end of the day.
Absolutely. And if you think about it, what were you doing going to the court for a date? I mean, it's, when you think about it, it's slightly bonkers, isn't it?
Yeah. Okay, so the end result is that we are optimistic about where the technology is going and the future of the justice system.
I am. I certainly am. And I just want everyone to be mindful of those aspects that I sort of urged caution on, so that we keep on recalibrating to make sure that we've got the experience right for everyone, and that you don't exclude anybody by, not intentionally, but you don't exclude people, as you were saying, who are not sort of tech savvy. You make sure that everybody is available and able to use the court. Okay.
So Amanda, thank you for this part. I suggest now to move to our second topic, which is why it matters that women are at the bar from bottom to top, and how to improve things at the bar and in justice. You have talked in your inauguration speech last December about the importance of the representation of women in the legal profession in the UK. So I would like to invite you to tell us a little bit about your thoughts on this. Why is it important that women are active participants in the legal profession, and how does this improve things or not?
Well, thank you very much. I think there's a very short answer to your question, and it's that we make up 50% of the population. I think I could just stop there, but I won't. So in the UK, it's been 100 years, 9 months, 1 week and 3 days since women were recognised by law as people, and therefore were allowed to practice in the legal profession. Before that, we were not able to be lawyers. So 2020 is the first year of that second 100 years. And progress is gathering momentum. In 2020, as I said, I'm the third woman chair of the bar in 8 years, but I'm the fourth in 126. I'm the second to have children, as I said, and the first of them to go to day school. And in my opinion, each of those women, great barristers before me, moved the dial for women in law. A little bit, and I hope that I will be moving it as well. At the Bar Council, we are very well aware that over 50% of barristers training are women, but that even from the beginning, there are problems with women getting into the profession, getting tenancies in chambers, and then there's it's not too bad, but then retention is poor and progression is an issue. So basically, we at the Bar Council want to make sure that we keep the women, those great women that we have at the bottom, and that we make their working lives as good as they possibly can be, so that they keep going, they don't drop out. Typically about 10 years post qualification, we see a lot of women leaving the profession, and even worse, that we then don't have women at the top of the profession. We don't have heads of chambers, we don't have leaders of specialist bar associations, we don't have many women who are chairing committees at the Bar Council, and we don't have what we should have, in my view, which is more or less every other year, is a woman leading the profession. So that is within the bar itself, but it also has a very, very big impact on the judiciary, because we are the main feeder profession for the senior judiciary. And so if we don't keep and nurture the women all the way through their careers to the point where they can become QCs, but also where they can become potential judges of the future, then the judiciary will not change. And at the moment, there's very poor representation of women in the senior judiciary. And just to take a very obvious example, our Supreme Court, there until last year when Lady Hale retired, there were 3 female Supreme Court justices. And then Lady Hale retired. There are 2 left. Both of them will retire in the next couple of years. And so you can see that that pinnacle of 3 women out of, I think it's 11 or so justices. Yeah. We're going in the wrong direction. And at the moment, it's not clear where the potential pool of women that could go to the Supreme Court might come from. And that's incredibly important. So as you will know, in the UK, the judiciary, the lower part of the judiciary is much better represented by women judges, but the higher up you get, the less and less there are. And I think it's a very, very significant issue, because actually bad enough that the professions don't have that representation of women from the bottom right through to the top. But it's even worse where you find that effectively 50% of the population is not represented, and their experiences and their views are not represented in the people that are doing the judging. I think that's an incredibly important thing. So what we are doing is looking in particular at the key challenges around retention, around practice areas, and also in particular, and I think it's something I referred to in my speech almost coming up for a year ago, the fair allocation of work is incredibly important to me. We need to have equality of opportunity for all barristers on merit, regardless of their background, their gender, their connections. I want the best people to be part of and thrive at the bar. And I feel strongly that as a profession, we must positively advance and sustain a culture of support for each other, so that everybody's practices are the best they can be, because that will better serve the public. That will drive access to justice. And that's actually part of the reason why I stood to be chair of the bar, because I'm not interested in tick boxes. I want women to be able to come all the way through. And so for me, it matters terribly, because it's important that society is represented in the profession. So we've seen also actually that COVID-19 has had an impact on, it's particularly affected women, particularly those with caring responsibilities. We already had in place a lot of initiatives to drive forward support for women. I mean, just to take one example, needless to say, when I needed it, there was no maternity policy in chambers and none promoted by the Bar Council. I am quite old, but still, you know. Now I'm happy to say that there is not just good practice that's set out by the Bar Council. There are lots of tools that we give to the profession to be able to support everybody. But those sorts of things make chambers better. They make you in the next door room, the next door lawyer, better by being able to discuss things with people with perhaps a slightly different view of things. And I think we need to drive change forward and not take our foot off the pedal. And that's particularly the case because we have this problem with retaining women and a lack of women in senior positions. So can I just mention perhaps a few of the ways in which we're trying to address this? There's a lot of them that are part of what we're calling the Accelerator Project. And what that is doing, and what a new initiative this year about which I'm extremely excited, is our new Bar Council Leadership Programme. And the idea behind that, it's not limited to women, but the idea behind that is that after you sort of have got into practice a bit, so you're no longer what we would call a young barrister, you've been there for over 7 years in practice, and that's when we're losing women, just after that time. And it's typically coinciding with childbearing years. But what we're finding is that there are many people who don't see themselves as being either leadership material or how they can make the best of their experiences and their career. And so what we've set up is this program, which is quite intensive, and we've just had 114 applicants for 33 places, so that's quite exciting. I'm doing a sift at the moment of part of the process. And the idea is just to give those people, and it'll be from all across the bar, different practice areas, within a bracket of between, say, roughly 7 to 15 years post-qualification, the ability to, as it were, discuss things across divides, including the gender divide, and to meet people that they wouldn't otherwise meet, and make networks and look at things in ways that can enhance not just their own practice, but their future as leaders of the profession. And I hope that what that will do, apart from anything else, is that there'll be brave and courageous speakers for the profession, but in chambers, they'll have the confidence to call out things that aren't right, to ensure that the work is properly allocated between different people. And we all have a part to play in that particular thing. But just coming back to the leadership program finally, at the end of it, what we are aiming for is that those 30 people would obviously be going back to their chambers or the courts that they appear in, or their specialist bar association, and spreading the good practices that they have learnt and the leadership skills that they have learnt to other people. So that, I think, is a really positive way of ensuring that women get that boost to see that the profession's engaging with them and believing in them and wanting them to stay. And I think that will be a very important part. Secondly, fair allocation of work. Now, I don't know what happens in Cyprus, but I can tell you here, there are lots of problems with fair allocation of work from all sorts of different angles. First of all, there's the client. The client might think he'd like somebody like Mr. Mr. Georgiou. He might think he's not going to try Miss Pinto because Mr. Georgiou's had experience of a particular type of case, and that experience means that he's then better placed to do it the second time around. Miss Pinto could do it just as well, but she's never going to get that chance unless there's a real look in your law firm at how the work is allocated. And the client might not actually be doing the best for themselves by just going to the same person over and over again. But we're all competing, aren't we? And so it needs to be thought about in quite a structured way. So that's one thing. And then secondly, it may be that you're in your law firm and you've worked with a more junior man before on a case. And again, they've done a good job. And so you quite like working with them. And so you recommend them for another case. But there's Miss Pinto sitting on the side. She hasn't had that chance. She'd be just as good. And so you have to make yourself kind of think outside the box a bit. And so from our perspective as barristers, we see the break with the client. We see it with the professional client, with the solicitor or the foreign lawyer. We see it with the clerks who are allocating the work in chambers. And we also see it with what we're calling kind of sponsorship within chambers. So that's the distribution of work from one barrister to another. I can't do that case. I'm busy. So I'm going to give it to X, or I'm going to recommend Y. And just those sorts of experiences are self-fulfilling, because if you don't get that chance, then you won't have the practical experience for the next time, and you won't be able to build the same career. as someone else. So those are really important to us. Confidential helplines, I think, are also really important, as well as mentors. But can I just deal with confidential helplines? We set up two completely different sorts. One is a person on the end of the phone. You can report wrong behaviour, bullying, harassment, whether it's from other barristers, whether it's on the bench. It can be anonymous, it's confidential, it's easy. But equally, that we have put in to the space a tool which is called Talk to Spot, and you can. It is a computer-generated program, and you can contemporaneously note something. Say a judge has mistreated you, without reporting it, without getting yourself into any trouble, because of course the problem is, isn't it, you don't want to have a row with the judge about the way they're behaving towards you that might impact on your client's case. So there's that inequality, and it's a problem. But with this app, what you can do is log it and then decide later on if you want to take it further and make a report. But it's just there. And that's been very helpful. And we found that actually we've adapted it so that it's particularly able, for example, to deal with COVID-19 issues. And we were talking a bit earlier about technology. I mean, if you can't, as the parent of young children who are homeschooling them, for example, get to court, but you could quite easily do a perfectly acceptable remote hearing, but the judge says, no, I want you all in court, and it's just to fix a date, let's say, and you say, well, I can't do that. Then they say, well, you'll just have to give the brief to another barrister then. And it's things like that. If it's unreasonable, then you can just log it. And we've got quite a few people who, for example, and typically women actually, who are carers, not just for young children, but for older, vulnerable people, perhaps doing their shopping and looking after parents and so on. And again, it might be that those sorts of issues arise more for women than they do typically for men. So those are things that we're really trying to open up to people to use, but in a way that's kind of not threatening and not worrying to them. Another thing that we're trying to address is the directories, like Chambers and Partners or Legal 500. So, I mean, that's quite a high profile indicator of the inequality at the bar that we have and the impact on women. If you look at the directories, which is obviously part of sort of public facing way of evaluating the strength of someone at the bar, you'd get the impression, I suggest, that it's not very diverse at all. There aren't very many women there. And actually, it's down to the way the directories get their reports, and it's a kind of self-fulfilling prophecy. I mean, go and have a look at the report, the directories. It's an interesting thing.
Okay.
So, yeah.
I haven't noticed this, to be honest.
No, why would you? Why would you? But I mean, in my area of work, for example, in the Legal 500, there's one woman in the top band, 2 women in the second band, and I make it to the third band.
And all the rest are men. Okay.
No, there's more women in the third band. I think there's 3 of us or 4.
Okay.
But not many. And, you know, there's some very good women at the bar. So it is just an interesting take on it. I did, before I finish, I did just want to just draw this out, which is that the crisis, the coronavirus crisis, has had a significant impact on the whole bar, but it's had a particular impact on women and those from minority, ethnic and socially mobile backgrounds. And we found that from surveys. And I think that the issue is actually because women tend to be the carers, they tend to be shielding. If, for example, they're pregnant, they might not want to tell anyone they're pregnant yet. and yet they can't go to court. So it's things like that that have been a particular challenge. But I suppose the real point is no one wants to wait another 100 years. Nobody wants to wait to drive what will be changes in the public interest.
Starting from the last point that you mentioned about logging on a computer program, a complaint or an incident that took place, can you give us a little bit more information as to how this will work? I mean, yeah. Will a complaint be filed eventually?
Yes, so it does two things, actually. The making of the report enables somebody in a completely anonymized way to, for example, see if there's a particular judge against whom there are lots of complaints. Mm-hmm. And we have a good relationship with the senior judiciary, and it's particularly open as a result of COVID, actually, because I have many, many meetings with them mm-hmm. to try and drive the volumes through courts. But if there is a complaint about a particular judge and it's only one, well, not very much is going to happen. But if in relation to the talk to spot, you find that there's a number of complaints or there's a pattern in a particular jurisdiction, for example, maybe it's that family cases sit very long hours, which is a problem and was a problem before COVID. That they expect people all of a sudden, instead of doing a normal court day of 10 till 4:30 or whatever it is, that they're suddenly there till 7. Mm-hmm. Well, that sort of behavior can then be logged, and so yes, something will happen with it, but it just will be anonymized. And I think that's a protection for people who are worried about their own reputation, and there certainly is a fear about the impact on your practice and having a reputation as a troublemaker or making a fuss. All of those sorts of things are obviously very off-putting. Mm-hmm. So it's useful.
Yeah, so the idea is to encourage barristers or women barristers to be more open about things that may take place in the work environment.
Yeah, but also it could be, you could witness it. You could be sitting waiting for your court case to come on, and you could log it on this resource as somebody who's got no interest in the case at all. You just see some conduct that you just don't think is right. And I think that's one of the other things, actually, that we're really asking people to do, which is senior practitioners in particular, because you've got a responsibility and you've got the wherewithal to do so, to call out bad practice when you see it.
So, okay, that's clear. So if you could see overall the legal profession in the UK, would you say that there is discrimination against women? I mean, would you go as far as that? Or there are some incidents, or there are things that need to be improved?
Well, there are certainly things that need to be improved, definitely. I would say there's a lot of, I think probably it's unconscious bias. I mean, when you choose, I'm not saying you, but when you choose the same young male lawyer to help you time after time, you're doing it actually as a shortcut. You're probably doing it because you know they're good, you know you work well together, you don't need to worry. But by doing that, without thinking about it, you're actually curbing somebody else's potential career. And you could actually have 2 great juniors, or 3 or 4. So I think a lot of it is just to do with norms of behavior that you just don't even think about. But I mean, I have certainly experienced inappropriate behavior in court, including by judges. And on the one hand, you know that if they were confronted with it, they would be, well, first of all, they would be shocked at the suggestion that they're in any way acting in a sexist way. And secondly, they would say, well, it's only a joke. And so it's knowing where the line should be drawn.
Mhm. So as a female chair of the bar, are women now more open towards you and they talk about issues and problems than it would otherwise be the case, or not?
I think so. I think so. I have had a lot of personally written emails as in my time as chair of the bar, which have been about these sorts of issues, and in a way that I don't believe I would have had if I had been someone else. But
Mm-hmm.
whether that's to do with me as a person as well, I don't know.
Mm-hmm. So, I mean, can someone categorize these incidents? I would say one category would be in the workplace and the behavior of clients towards female attorneys and barristers and the behavior of their bosses, their superiors. And then the environment at the court and the behavior of judges towards women. So would you say that, for example, in the second category, things are better? The behavior of judges, female or male judges against female lawyers is less problematic, and the problem is in the workplace at the chambers.
I think all of it has improved.
Okay.
But I think there is definitely still room for improvement in both.
Mm.
And I think, I mean, actually, only today someone wrote to me with an experience in a courtroom which should never have happened.
Mm-hmm.
So I don't think it is better in one or the other. But I think there are problems all the way through. And that's what I was trying to say, that we're trying to address all the way through.
Mm-hmm.
And I think one of the reasons, so if I may just say, I think one of the reasons is that there's just a lot of imbalances of power all the way through, very particularly. And without, the way barristers work, that we're not employed. So none of the employment issues, that none of the structures in ordinary employment and employment law seem to work. Barristers are kind of quirky and, they're all self-employed and they've got their own way of doing things. And I think that superficially allows people to think that they can kind of get away with things, which they just definitely shouldn't be doing. But a lot of it, at root, I think it is just an imbalance in power. So it means that you think you can't say anything about it.
Yeah. So previously you mentioned about the participation of female justices in the Supreme Court, and you said there are only 3 now after Lady Hale's retirement. So what is the problem there? Why aren't there any appointments? I mean, there are not enough high court female judges that could eventually.
I think it's to do with the 2 things. One, it's to do with the pool of people who are there, but it's secondly to do with perception. And if you think about it, people typically recruit in their own image, and it's difficult to get beyond that and see that there are other ways of getting excellence that would be great in the Supreme Court, for example, in any walk of life. I mean, you probably know, but in law firms here, the number of senior partners that are women is the number of partners that are women is very low. They have well over 50% women in solicitors' firms at the bottom. But the number of partners is low, and when you get to magic circle firms, when you get to the city firms, it's extremely low. And I think it's the same issue. It's difficult because when you look at the kind of things we're trying to do to retain women, what you have to think about, I suppose, is that if those structures and that help isn't in place, and it obviously wasn't 15 years ago, then you're going to have a different group of people who will have managed to sustain themselves throughout. And I mean, it's interesting, isn't it, that Lady Hale actually came from an academic background. So she had not gone all the way through her practice at the bar and then joined the bench in a traditional route for a male Supreme Court judge. And also Lady Black, who's one of the other two. Again, an academic. She left. They started off as barristers. They quickly left, and so I think that says quite a lot. Actually, they had what would be a non-traditional path for a man.
I didn't know this. So, but Amanda, isn't this a societal problem? I mean, you can see these things, these patterns, let's say, in other professions, the accountants or others. So it's not a legal or a lawyer's profession problem per se, is it? Or do you think because of the difficulties and the peculiarities of the legal profession, we see that this is more evident?
So I think you're right. It's a problem with professionals and professions, and in banking as well. The first thing I would say is I don't think that's an excuse at all. We've got to sort it out in our own profession. But I do agree with you that it's not just limited to lawyers. But to come back to the big point, I think in the self-employed bar, it is this issue of there not being structures. And that's why the Bar Council is so important, actually, because every chambers has its own way of doing things, and some will be good and some will be not so good. And we want all of those chambers to learn from the better ones and from what we're saying is the way they should be approaching this.
Yeah. As a Bar Council, is it possible for you to, let's say, force chambers to enforce certain guidelines, or you just, you are trying to be persuasive as to the implementation of certain policies?
Yeah, I think there's two things. I don't think we can force it, but I think what we can do is just demonstrate what is best practice. And when it comes to people choosing which chambers to join, and I think this is true whether you're male or female, frankly, you want to go to the ones that are best run. And what we know is a fact generally in life is that having a big mix of certainly genders makes for a much more successful business model. So it's more profitable to have men and women working rather than just men. Why would you not want to be in a successful, well-run chamber? So we think that that's part of it, will be the attraction for the best new people to join those chambers, and equally for people who are there and see better practices elsewhere to leave and join those that are better run.
Yeah,
I think that's the way that we try to do it. And it has changed. I mean, you know, if you think about it, if everybody's self-employed, you could argue that you don't need to have a maternity policy in chambers, because the barrister who's having their maternity can do what they like. But actually, a good chambers wants to support its practitioners and wants to make sure that all of that experience and excellence and expertise doesn't get lost because the woman says, well, you treated me really badly, I'm not coming back.
And as you correctly pointed out, during the COVID lockdown, the mothers, the caretakers, are the most affected, aren't they? I mean, they had to stay at home, take care of children, or at least most of them. Yes. So this is another problem that deteriorates this the whole situation.
Absolutely, and it's absolutely borne out by statistics. And in fact, the other thing that is it exacerbates is that they are more likely to be doing publicly funded work, and they're more likely to face greater financial pressures. So it's that sort of triple whammy effect of being female, having all of the issues that there are there, being in a less well-resourced part of the profession in the first place, because you're more likely to get in if it's not so well remunerated, and facing greater financial pressure. So it is difficult.
I mean, this is a huge discussion, of course, and there are many aspects involved. As we move towards the end, I would like to take you somewhere else about the role of the legal profession in today's world. And I noticed from the interventions that you make that as a bar council, you participate actively in the political arena, let's say, in the UK. And I read an interesting statement that you issued recently about the role of lawyers. And let me read a bit, a paragraph, and I would ask you to comment. Of course, I won't say what the background was. It has to do with politics, but yeah. I'm interested in the principle. You said that lawyers carry out their duty and apply the law irrespective of political persuasion in accordance with our professional standards. Given our duty to the court and our commitment to justice more generally, barristers as well as solicitors must do just that. It is not the job of lawyers to limit Parliament's own laws in a way that the government of the day finds most favorable to its political agenda. The law, not politics, is what matters to a profession that upholds the rule of law. So my question is, how difficult is it in today's world and in today's politics, and in Britain in particular, for the legal profession to do what you say, to uphold the rule of law?
Well, I would say at this moment that there are some members of the government, and actually today our Prime Minister, who attacks lawyers verbally, and I'm shocked actually that is the case. But what I really want to do is to ensure that the public understands what the role of the lawyer is, and it seems to me that that is the most important thing, because you can have people who are saying things that aren't accurate. I mean, what's frustrating is that it is the lawyer's job to put forward, as the mouthpiece of the client, the best arguable submissions based on the law. And ironically, I find, with what's going on at the moment, the government's in a position to change the law. It's got a massive majority. Don't complain about the laws that are there, that we are simply using as they're supposed to be used. If you and then complain about the lawyers that do that. Change the law if you don't like the law. But no one's above the law, and no judge will apply the law deliberately wrongly. So it seems to me it's frustrating actually, because it's a kind of misinformation. It's as if we're not doing our job properly, when we are absolutely doing our job properly. And you ask us, how hard is it to do our job properly, to uphold the rule of law? I think it is not a good thing when the government, by the way, it's paying for many of these lawyers that it's also complaining about, because we are paid for to prosecute and defend, or to take claims or not take claims by legal aid very often.
I read the part from the announcement of the Bar Council, which ends, the law, not politics, is what matters to a profession that upholds the rule of law. And my question is, how difficult is it today for lawyers and legal professionals to uphold the rule of law and do just that without interfering in the political arena?
Yeah. So I think it's more difficult than it should be for lawyers to uphold the rule of law and do their jobs properly. And what I find the most frustrating is this idea somehow that the public is being misled into what the job of the lawyer is. The job of a lawyer is to be the mouthpiece of their client. And if they're entitled, and it's their job to put forward all the best arguments they possibly can. In the case, nothing to do with politics, to do with law. Mm-hmm. And it is undermining to have people suggest that that is not what you should be doing, just because it doesn't suit the politics of the day. Mm-hmm. And having said that, I think lawyers are robust, and I think we're not very happy about how we're being portrayed. But as I think I said, our duty is to our client and to the court, and that's what matters.
Mm-hmm. Okay, this is a very interesting answer. Thank you so much, Amanda, for all the discussion we had. I think we raised very interesting and valuable points, especially the part the discussion about women and the participation in the legal profession is very interesting for me, because we have similar things and issues in Cyprus, and we don't discuss them that much, I think. I would also like to
come over and discuss them with you.
Yeah, you are welcome whenever this the lockdown is over. We would be happy to host you here and do a conference with my colleagues and discuss these issues. So I would like to thank you very much. I would like to thank the British High Commission for giving us this opportunity to make this discussion and offer this to the public. So I will give you the floor to say a couple of last words, and then we are done.
Well, Christopheros, thank you so much. It's been an absolute pleasure. As you can tell, I really love talking about being a lawyer. I love being a lawyer, and it's always my great pleasure to be involved with the Cyprus Bar and my friends in Cyprus. So thank you very, very much for having me.
Thank you so much. Thank you so much, Amanda. Hope to see you soon.
Me too.
Bye-bye.
Bye.